Hello and welcome to this Working Life podcast, the third in a series of podcasts produced by the Institute of Employment Rights. Throughout this series we'll be looking at the Employment Rights Act 2025, what's in it, what's not in it, and why we believe a second employment rights bill is needed. As usual with the Institute, those involved in these podcasts are all leading experts in labour law. The first in this series heard Lord John Hendy speaking to Professor Nicola Kantoris on the background to the Act. The second was a discussion between Lord Hendy and Tonya Novitz on the right to strike. And today we are kindly joined by Neil Todd, who will delve into the details of fire and rehire. But before I introduce Neil, I should introduce myself. My name is Carolyn Jones. I am Senior Vice President of the Institute of Employment Rights, and I'm honoured to be here hosting today's session. I'm very pleased to welcome Neil. Neil Todd is a partner at Thompsons Solicitors, the largest firm of solicitors servicing the trade union movement. He is a senior employment law and trade union expert and a familiar face in courts and tribunals whenever workers and unions need top-level legal representation. He's also a familiar and welcome face at many Institute events. So, Neil, thank you very much for taking the time to speak with me today.
No problem, thank you for inviting me, Carol.
Good to see you. As I said, we'll be exploring the strengths and weaknesses of fire and rehire provisions in the Employment Rights Act. So, to start with, Neil, can we start by reminding ourselves about why changes to the law on fire and rehire were necessary in the first place, and perhaps when the new law will actually come into effect?
Yes, thanks, Carolyn. It's been notoriously a weak area of law for some time, with employers having a great deal of flexibility under the current legislative framework to dismiss employees and re-engage them on less favourable terms and conditions. One of the reasons for that really is that the case law provides that they only need to show a sound business reason for it. The tribunals have very little inclination and indeed aren't able under the framework to interrogate that reason very easily. So provided that that reason can be made out in very broad terms, then they simply need to follow a fair procedure. It's a practice that's gone on for some time. I think it probably became more prevalent in the pandemic, where we saw really high profile examples of it at BA and in British Gas, to name but two. And then we had an ACAS code of practice was introduced by the government in response to that, but really didn't add much meat, if you like, to the law in the area. It was very sort of superficial changes. And we also had a very high profile event at P&O, which was probably the most notorious fire and rehire incident we've seen certainly over the last 50 years of employment law. That was a real watershed moment, and therefore Labour came with this commitment that something needed to be done, and they campaigned on a manifesto pledge that would be to ban fire and rehire.
Yeah, absolutely. And it was about a year ago, Neil, when you joined us on a previous podcast. And I remember you saying that you were sceptical about whether the Employment Rights Bill would be able to stop a repeat of the P&O scandal. From a trade union perspective, do you think the current drafting actually closes the door on these practices, or does it still leave a few escape routes allowing employers to practice that bad practice to continue?
I think it's been a bit of a mixed bag. There's been some changes to I should start at the outset by saying that what was enacted never actually banned fire and rehire. The provision in its original form fell well short of that. I know we're probably going to go on and talk about some of the exceptions later in the podcast. But sort of moving forward, the provision as it stood has been changed positively in some ways that I think does help address a P&O scenario. But in other ways, we've also seen some changes that are less advantageous to workers. So I suppose on a positive side, the two things that immediately spring to mind, when the provision was first introduced, it was said to be unlawful if you were going to dismiss and re-engage your own staff on varied terms and conditions, or if you were going to recruit, dismiss your own staff and then recruit new employees on those less favourable terms and conditions. And that didn't deal with a situation like P&O, because what P&O did was dismissed its existing workforce and then effectively engaged an agency workforce that it would never have a direct employment relationship with. So that was one gaping loophole that was identifiable in the original provision, and that has been closed off. So for instance, it's clear now that you can't fire and replace an employee with a worker of any description, including in those agency arrangements. So that loophole has been closed. Another thing that we were very worried about at the outset was the fact that these wide flexibility clauses, which effectively you have a term in your contract that says we can change any term and condition at any stage. Now what we have now got is a commitment in the new legislation, or I should say a provision in the new legislation, which will make it unlawful for an employer to dismiss and re-engage, where it seeks to introduce a variation clause which would allow it to change certain prescribed terms and conditions. But in other ways, the provision is now weaker than it was. So for instance, when it was first introduced, it was going to be unlawful to dismiss and re-engage an employee for changing any term and condition. And then we moved to the fact that not all terms and condition, it wouldn't be automatically unfair, I should say, to dismiss and re-engage for all terms and conditions. That would only be the sense if it was within certain prescribed terms and conditions. So things like if it was to change your rate of pay, if it was to change your holiday allowance, if it was to change the hours at which you work. And therefore some terms, it would no longer be automatically unfair to change. And then even more recently than that, we now have a consultation process about some of those prescribed terms, which we may well go on and talk about, which seeks to narrow those prescribed terms even further. And that's come from very strong voices at the employer lobby, and this continued emphasis on employers needing flexibility. And the idea is we were moving away from that one-sided flexibility, but it's certainly being clawed back. And we'll see what happens in respect of the final position on these consultation responses. But I am concerned from that point of view that the provision is not as strong as it was.
Thanks for identifying where the loopholes have been closed, worrying that there are still some gaps. You talked about the consultation process. Do you know when that is? Where are we up to with that?
It closed on the 1st of April, and it looked at two things in broad terms. The first was it looked at expenses and benefits in kind. So what it does is it seeks to exclude from the restricted variation ambit on pay any sort of benefits in kind that are paid to employees. So that's things like travel allowances, tied accommodation, those sort of things. Now there's two options given. One is, and the preferred option of the government is that all payments in kind and expenses would be removed from the definition of a restricted variation. So what that means is it wouldn't be automatically unfair if you wanted to dismiss and re-engage someone to change whatever their entitlement was under a travel policy, or in regard to accommodation that's tied to the salary. And you've got to think about, in some sectors, perhaps tied accommodation could be a key thing. So if you think about teachers who sometimes live in accommodation prescribed by the school, you think about workers on oil platforms get accommodation. If you think about workers in care homes, often there's tied accommodation. That could be a key component of their sort of overall salary package, and you are stripping that out of this definition of a restricted variation. The other option they've put forward, but it's not their preferred option, is that you would only strip out from the definition of a restricted variation benefits that have the same characteristics of pay. But even if that was implemented, there's a very difficult line to draw as to what benefit does have a very similar characteristic to pay and what does not. And my view is that they should leave that alone. The other side of the consultation is about hours. There's been an incredibly strong employer lobby saying that hours should be taken out. We should have the freedom to be able to change people's hours. So the restricted variation they're looking at now is narrowed in a sense that the government's preferred option is that any restricted variation would only be if it changed your hours from daytime working to nighttime working, or from week working to weekend working. And any other variation to those hours would be permissible. And again, yes, that is addressing perhaps the most extreme changes to working hours, but it can be fundamentally difficult to workers in all sorts of different sectors if their hours are changed in ways that don't fit within those narrow parameters. And who's to say it's not more difficult for your hours to be changed from working on Monday and a Tuesday to a Thursday and Friday? I mean, your whole sort of way that you structure your life and your commitments around that could be centered on that working pattern. So again, it's unfortunate that it looks like there is a sort of an impetus to make some change there, and that could weaken provision quite significantly, I think.
Well, we'll wait and see then what the end result of that consultation before it actually becomes into law. You talked about some of the exceptions. One of the main exceptions is the business necessity or financial difficulty exemptions. Do you think that they risk undermining the protection of the Act and what it was trying to introduce?
I think when you first look at that provision, you think it's fairly narrowly drawn, and you would hope that it would only apply in the most extreme of circumstances. But I think that it will be very much dependent upon how it's ultimately interpreted by employment tribunals, and it will be very good to see some guidance around the application of that. I mean, for example, it talks about the way that it's drafted is to sort of eliminate, prevent, or significantly mitigate any likelihood of an employer being unable to operate. I think it's either they will be unable to operate or they're unlikely to be able to operate. And there's concern around the use of that word likely. The word likely has a lot of different meanings within the employment law framework, and if you are interpreting likely as something that may happen, then you can start and see that it becomes more difficult. You get employers who can present their sort of financial position in a multitude of different ways. And there is a risk, I think, around that massaging the sort of financial viability of a company and presenting a court with a position where it can be shown that this is likely to happen on that watered down test, and then we may see that provision isn't as strong as it initially appears at first glance.
I know at the Institute, in one of our previous briefings, we suggested that an independent auditor should be used to confirm the changes are generally essential for survival. Would that help? And is it even likely to be anywhere near to be introduced?
I think that definitely would help. It's also a point we made in our consultation response at Thompsons. I think there's absolutely no chance of seeing anything like that written into the provision. But yeah, I mean, what would be to stop some guidance saying that is the sort of level of evidence that an employer would be expected to show? I think that would be useful both in terms of proving what the true financial situation is. I think it would give employers certainty to understand what position they need to be in and what evidence they need to show when they're going to, if they're going to defend a case on the basis of relying on this exception. And it would be a sort of at least a win for the trade union movement in terms of being able to pin the government to showing that this is what it's meant to be, about a very, very serious financial situation that's threatening the existence of an organisation.
Yeah, absolutely. Yeah, thanks for that. You mentioned from a trade union perspective, what key reforms do you think are still missing if the goal is to genuinely prevent fire and rehire practices rather than to regulate them, which is what the Act seems to do at the moment?
Yeah, I mean, I suppose it'd be picking up on some of the points that we've already discussed. I think that the one thing that I think is missing that we haven't touched upon today is around remedy. What the Act initially did, or when they were consulting about the provision, what they talked about was the potential to have interim relief available for dismissals relating to fire and rehire, and that would have been really important because we have a sort of a legal framework which is punitive in nature. In other words, that you as an employer dismiss your employees, and then the way it works currently with the tribunal overload is that you wait 12 months till you have a hearing, and then you may have to pay a compensation at least. And what interim relief would have done, it would have made a significant difference in terms of giving the possibility of preventing those employees from being dismissed in the first place. It would require the employer then to continue to employ them if you're able to establish your case at an interim relief hearing. The employer is then compelled to continue to pay those employees until a full hearing, and that would have prevented some of these sort of worst case fire and rehire situations from happening in the first place. Now, the government said that would be too difficult, it would be too much of a burden on the employment tribunals. The level of evidence that you have to show in a trial would be too great to do in such a short space of time. But I really think that was missing a trick, and that sort of strong remedy is the most effective way of stopping fire and rehire. In terms of other things that they could do, I think it comes back to this point around the consultation. My view is I think it's very unfortunate they moved away from all terms and conditions being protected in the first instance, and that there's now this two-tier system with restricted variations. But I would strongly urge that there is no further watering down of those restricted variations, and that they remain in full, and no regulations are implemented to narrow that, to carve out certain shift pattern changes and payments of certain benefits in kind or expenses. Unfortunately, it doesn't look like that's the direction of travel, but that would at least I suppose stand by the original provision that was made, rather than watering it down yet further. I think an absolute ban is going to be very unlikely, but as we've touched on today, I think sort of further guidance around this financial exception, so that everybody is comfortable that is just about the most extreme, the most extreme circumstances, that would be very welcome as well.
Right, yeah. And a lot of work that the Institute has done over the years, as you know, and often with Thompsons, is looking a bit broader than provisions for fire and rehire would be. If we had something like sectoral collective bargaining, then that P&O situation that you described would be much more difficult, because if terms and conditions were set across a sector, then you wouldn't be able to have an employer like P&O being able to recruit new staff on lower terms and conditions that were actually being implemented across that sector. So that's much broader than looking just at fire and rehire. But it is it would be a fundamental basis if only we could have it.
I agree, and I think that is something that trade unions must continue to fight for, and obviously that is a key cornerstone of why many of us think that the second bill would be a good idea, where we could drive wider change of that nature. I don't think we should lose sight of that being a real aim for the future.
I agree. So the Act still relies heavily on individual tribunal claims and compensation after dismissal. From your experience representing unions, is that model strong enough to deter large employers, or does it risk being treated as a calculable cost that the employer can build into its planning? I
think it's still a real risk that there's a calculated analysis done. We all know that's what P&O did. They did a sort of a broad calculation and worked out that it would be better to reach settlement agreements, enter settlement agreements with their own employees to pay them what they might one day be able to claim at the employment tribunal, rather than adhere to the law. Now, we've seen some steps to address that. For instance, we've talked about some of them today. Another obvious example is the doubling of the protective award from from 90 days pay up to a maximum of 180 days pay that's just been introduced in April. But, you know, we talked about interim relief earlier in fire and rehire situations. They talked about the option of interim relief both with regard to fire and rehire and in regard to a failure to collectively consult, and they disregarded that as a step, and that would have been the clearest thing to do to signal that you can't just buy your way out of it. So we're still left in a situation, I think, where yes, the financial penalties are now going to be slightly more significant, but there's no extra funding for employment tribunals, so any financial compensation workers do get is likely to be 1 or 2 years down the road, and we know that many employers will make, or you know, many unscrupulous employers, I should say, will make it the kind of calculation that yeah, there is a risk we'll have to pay a bit more, but it's worth that risk to sort of drive through what we want to do now and to sort of change terms and conditions, you know, to the detriment of workers. So I do worry that it is likely still to be driven by naked financial calculations, even though the whole purpose of this really was to address, or not the whole purpose, but you know, a big driving force behind this was to counter that kind of tactic that P&O deployed.
Yeah. And as you know, because I think Thompsons were involved as well, I mean, there is a piece of legislation already sitting there ready to be considered through the Barry Gardner's bill. It was many years ago that proposed many of the things that we're talking about here today, and it still sits there but not implemented. Maybe we could revisit that.
Yeah, it's not being given any airtime, really, has it, through the employment bill, and it very much taken things into another direction. But that certainly strengthened workers' rights in many respects about many of the issues that we're talking about today, and would well be worth looking at if we need to, but when these provisions need to be strengthened again, if we get to the stage where a second bill becomes a real possibility.
Well, as you say, that seems to be a bit more on the campaigning trail at the moment. Campaign for Trade Union Freedom, few unions, other organisations, even some MPs are now coming down to, do we need another employment rights bill to fill the gaps that this current Act has failed to deliver on? Great. Well, I think we're out of time. So, Neil, it sounds like while the Act strengthens protections on paper, there are still some concerns from a trade union perspective about loopholes, about employer flexibility, and whether enforcement is strong enough to prevent situations like P&O happening again.
I think that's right, Carolyn. I think that this was all about ending it was given the label of ending one-sided flexibility, but we're seeing more and more of that creeping back in. All the government consultation papers now are continuously sounding this idea that employers need flexibility to do A, B and C, and that seems to be moving away, that narrative in particular seems to be moving away from, you know, what we all wanted from this bill.
Absolutely. Each time there's a consultation, you shudder a little bit about what you're going to lose next.
Rather than what you're going to gain. Yeah.
Absolutely, yeah. Well, that's been really interesting, Neil. Thank you for that. Thank you for joining us. Thank you for being so generous with your time and sharing your experience with us. And we look forward to seeing the podcast on the next series. So, thank you very much.
Thank you.